Yeah, it's done. Yeah, you're done. I have done completed. Yeah, yeah. It's, okay, right. Thank you. Hello. Okay. Yeah, 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 yeah. Good evening, Professor Raghavan. It's almost 6 now, so participants, about half the participants have joined. So they will be joining now. Should we start the session? You want to wait for a couple of minutes?
It's up to you. If you want me to wait, I can wait, or we could
Yeah,
start now.
I think we should start on time. Yeah, request you to take it forward. I'm making Mr. Sean Brown the presenter now.
Okay.
Good morning, everybody. Can you hear me?
Yes. Morning, Sean. We can hear you. And can I introduce you for a second, and then we'll start?
Yes. Thanks.
Yeah. Okay. Good morning to everyone in the US and to everyone in India. I'd like to welcome Mr. Sean Brown, who's the Vice President of Government Affairs at Pharmaceuticals. He's based out of Washington, D.C. Mr. Sean Brown is going to present on issues that both Indian and foreign generic pharmaceutical companies face in the United States. This will be one of the last presentations on the last day of the Executive Education Program that's co-hosted by the Confederation of Indian Industries with Texas A&M University School of Law. So thank you, everyone who's participating. And with that, I would like to hand the mic over to Sean. Thank you.
Thank you so much, Sri, and thank you for working so hard to put this meeting together. These kind of meetings, back when I started in this industry, were pretty much unheard of. So I think it's pioneering of you to get out there and put panels together like this. And I've always thought it would be a good effort for the industry to make, because if we can reach out to students and people who are curious and want to learn about this, maybe we could start to change the perception of our industry to some degree. And so I wanted to talk about the challenges to also Indian pharmaceutical companies, generic pharmaceutical companies, but they really apply across the board to anyone who's in the generic industry in the U.S. My background is heavy into the generic side. I was way back an English teacher, but when I started in DC, I started as a lawyer, started working at the trade association, and I was given international government affairs was one of my books of business. And so I want to talk about that, but getting into trade and with some depth. But I want to talk about also, what is presently in the mind of companies like mine, what we're contending with, and what our advocacy efforts are doing. I think this sort of goes to the biggest challenge, or one of the biggest challenges for our industry is our reputation. And I can speak for the entire pharmaceutical industry in saying that we have a real challenge there. The perception of the pharmaceutical industry in the United States is very negative. It has been for a long time. It's sort of big bad pharma is what people know. Policymakers are, sort of we're a popular target for bipartisan approach. No matter who wins the election, our industry is going to have to look at a lot of new policies that are going to impact us and impact our ability to compete. And from that reputation, I think so many other issues stem from that issue that, people perceive that manufacturers of pharmaceuticals are greedy and don't care about patients and that sort of thing. So I think that's tragic, because I think it's really been a few bad actors that have really caused that. If I talk to my parents, who they don't care about what our industry does politically, so I kind of use them as a touchstone. And what they know, they'll have heard of Martin Shkreli and the pharma bro who raised prices on a HIV treatment 5,000%. That's what makes the headlines. That's what people think of us. And so from that, you sort of have not a lot to defend yourself in the arena of public affairs. And I'm going to talk about things sort of in terms of before the pandemic and during and after, hopefully, the pandemic. Because before the pandemic, our industry was reeling and really looking for a way to educate the public about what we do and about all the good things that the generic pharmaceutical industry can do. The huge savings that generic competition provides to the United States is it's all-encompassing. We're talking about 90% of the prescriptions in the United States available for only 22% of the total spend. That is a great story for us to tell. I wish more people were aware of that. But if it weren't for generic competition, you look at the reciprocal of that. So we're talking about 10% of the medicine that's soaking up 78% of what we spend as a country. So generic competition is really the best success story in healthcare in some ways. And in terms of the impact of public health, it's inestimable. But again, our industry, no matter what good it's doing, it does get swept into this sort of unpopular image of greedy pharmaceutical companies. And then you have piling onto that, before the pandemic, the Bottle of Lies, the book by Catherine Ebon, had come out. And, the information was 10 years old, and things have come a long way since the stories that are in that book were told. Ranbaxy is a company that she focuses on in the book. They don't even exist anymore. And she brings up issues that have been addressed, like inspections, for example. Our industry, through the user fees, generic drug user fees, has invested hundreds of millions of dollars in supporting FDA inspections. Then you have the book, China RX, which comes out, and it sort of adds to this fear and anxiety about foreign-made products. Well, estimates for what is manufactured in India and comes to the United States as medicine is about 40%. So, in any industry, there are going to be quality issues, and there are quality issues in the pharmaceutical industry that need to be addressed, absolutely. But you look at India. India is a country with over 500 FDA-approved manufacturing sites. And if we, the generic industry, are providing 90% of the prescriptions in the United States, to me, any reasonable person has to conclude that this is a strong, high quality industry. What makes the headlines is not the consistent day-to-day delivery of safe and effective medicines. It's when there's a mistake, and it's not surprising, since medicines are things that we all have to put in our bodies, and we're all patients, so it's, you know, particularly sensitive issue. So, you know, that didn't help our reputation. All of those things didn't help our reputation. Then on top of that, you had the Attorney General lawsuit, about 47 states suing the generic industry for alleged collusion. We were called the largest cartel in U.S. history, and I not to make light of that at all, but I have to laugh a little bit to myself, because I'm thinking, if we were a cartel, we've been doing a terrible job, because our prices have been going down for the past 5 years consecutively, and that actually leads to what I think is a deeper problem underlying that, which is, in the United States we have consolidation of buyers. So when I started in the pharmaceutical industry, there were at least 10 or 12 distributors of pharmaceuticals nationally. Since then, there's been huge consolidation in that side of the industry. So if you start with manufacturers, just big picture, manufacturing, wholesale, distribution, and then pharmacy or dispensing. In the manufacturer side, there's plenty of us making drugs. But in the wholesale side, you have 3 major distributors in the United States that are responsible for over 90% of the supply. So the change from, you know, multiple distributors where 6 or 7 manufacturers can compete and each using a different distributor, those times are gone. Now you have 3 distributors, as I said, and if you're not doing business with one of them, you're not doing business in the United States, pretty much. And there's some secondary wholesalers out there. It's not an absolute, but it's a vast majority. And so the leverage that you are up against when you're a generic competitor, and I'm not talking about the brand industry at the moment, when you have a single source product, when you have multi-source products and you're trying to compete for one of those buyers to pick up your product, you know, prices are driven way down. That's a good thing for the public. What's not a good thing for the public is thinning out your supply chain, making it more vulnerable. Like if you have 6, 7 makers of a particular product, a medicine that people need, that's a solid supply chain. If 1 or 2 of those competitors goes down, if there's some kind of quality problem, or if there's a force majeure event, something like that shuts down production, it's resilient. The supply chain, the manufacturers can step in and fill that gap. When you're cutting it down to 3 competitors, it's not so resilient. You lose one of those competitors, you may not be able to make up the difference. So it's hard to argue this to policymakers, because it's very hard to quantify or to point to particular anecdotes that would resonate. But it's a really general issue, where when you have any consolidation in the distribution market now, what they do, they call it price harmonization. So if big distributor A gets together with big distributor B, they decide that they're going to give the prices that are the lowest from either side, and i.e. they call it harmonizing. So this is driving down not only the prices, but it does drive things down to where, you know, FDA puts out a list, 2 pages, single spaced, of products that are off patent, meaning they don't have intellectual property protection anymore, so anyone could make them, but nobody makes. And these are medicines that patients need. And why doesn't anybody make them? Because competition has driven it so far down that it's not profitable anymore to make those medicines. So policy makers are looking at that issue, and I have to give credit to former Commissioner Gottlieb for highlighting this issue, you know, sort of bring it to the attention of the legislature and regulators more emphatically. But that consolidation of buyers is a huge obstacle for a generic competition in the U.S. And not only is it consolidation within the wholesale industry, now it's branching out to be longitudinally, or what's the word, laterally integrated, or vertically integrated, where you have a wholesaler under the same roof as the PBM, the pharmacy benefit manager, and the pharmacy. So the buying leverage gets even bigger when you have that kind of consolidation. And that's forcing a lot of companies to cut products that are low margin or like negative margin. And that is bad for the public. I think it weakens the supply chain. It makes us less resilient when there are issues. So that is I think that is a general overarching challenge to the industry. And we looked into it to see if there were, antitrust arguments that could be made, and we contemplated approaching the FTC with this. But the issue was that we couldn't really come up with a single evidence, it's like single issue that really illustrated this evidence to them, because it's sort of fluid, and maybe a problem pops up here, lasts for 6 months, then it goes away, like a shortage. Excuse me. So I think we're going to keep looking at that issue and keep scratching at it, because it is recognized by, as I said, Scott Gottlieb recognized it. I think people at the Federal Trade Commission recognize it. It's a question of what to do about it, if there's anything to be done about it. But that consolidation of buyers is a major issue, and so is reputation. I'd say those two things are really what a lot of other problems are stemming from. And then kind of moving to the more recent past and present, with the pandemic, our industry's had challenges, and probably not as bad as other industries. I mean, other industries have collapsed. Our industry has not collapsed. In fact, it's been resilient throughout the pandemic. I can say for Lupin, we've been able to stay operating and keep our facilities running throughout, and we haven't really had any problem with shortages to date. And I think that's generally the case across the board. So the pharmaceutical industry today is resilient. It's stood up to the pandemic, and generic medicines play an important role in bridging us to a vaccine. These are the medicines that are currently treating people, treating symptoms, and helping people to recover. We don't have a vaccine yet, but in the meantime, we're trying to, do our best to mitigate the impact on public health. And this industry, as seen, has been dedicated not only to keeping the flow of medicine going, but also in terms of corporate responsibility. I won't spend a lot of time on that, but I'm proud of this industry. I think we had an opportunity where the spotlight was on us, and we stepped up and showed our true nature. But I want to talk a little bit about the executive orders that have come down, because those are really reflections of broader policy sentiments in the industry. What President Trump has put out there on those executive orders are ideas that have been around for years, and they're interestingly manifesting now. And it remains to be seen how those orders are going to really impact our industry. But if you look at one of his executive orders was to eliminate rebates. In other words, he refers to pharmacy benefit managers as shadowy middlemen. So pharmacy benefit managers are the organizations that set up formularies for commercial insurance, set up formularies. They have influence on formularies within Medicaid and Medicare. And they kind of control what gets added to a formulary. And the situation that not only Trump, but a lot of policymakers are looking at is where a brand company is selling their single source product to a PBM. When generic competition then becomes available, you would assume, say, if something was priced at $100 for a prescription, and a generic competitor comes in at $70 or $50, rational people would say, okay, so we're gonna buy the less expensive, equally safe and effective medicine and sell that to our people. So that makes sense. It's less costly. What happens is brand companies will negotiate with pharmacy benefit managers and say, I want to be exclusive on that formulary, and in return, I will give you a big rebate. I'll pay you, part of what I make on that to the PBM, and those rebates are lucrative. And so if you're a generic competitor, let's say you're the first generic, you've taken a big risk, you've challenged the patent, you've got your product formulated and ready for approval, and you get out there into the market and you find that pharmacy benefit managers, plans, insurance plans are saying, well, the margin I can make on your product is not as great as the bird in hand. A bird in the hand is worth two in the bush, as they say. So if I'm already getting this stream of revenue from my rebates, and then a brand company says to me, look, I'm going to leverage this. If you want to keep my product and keep these rebates flowing, you need to keep me exclusive on your formulary. It's playing out right now in a big way with the lawsuit between Johnson & Johnson and Pfizer over infliximab. So Pfizer ventured into biosimilars, made a biosimilar product of a Johnson & Johnson product. Johnson & Johnson said to the pharmacy benefit managers, make me exclusive on your formulary. I'm going to bundle my rebates, not only for this product, but for all the products that you're collecting rebates on. And I'll take those away if you don't keep me exclusive. So this is the rebate trap. And you might have seen some news out there about this. But the problem is that squelches competition. If I'm a biosimilar manufacturer, Lupin is, I have to put that factor into my calculus and my decision to go into business and my decision which product am I going to target. And if a company like Pfizer, who we would assume has all the wherewithal and resources to challenge this Johnson & Johnson, which they are, if they can't get through this, I think it's going to be a tough pill to swallow for the rest of the industry and for the public, really, because there's a strong interest right now in having a robust biosimilar industry, because biopharmaceuticals are the most costly medicines today by a long shot, responsible for over 70% of the price increases over the past 5 years, are biologic products. And so we need competition in that area, in that sector of the industry. And that is biosimilars. So you have a lot of companies, and there's a mix, traditionally generic or traditionally brand companies, both getting into the biosimilars industry, which I think the public really needs to lower those costs. However, because of this dynamic that's been identified by the Trump administration and others, those rebates are blocking our access to those formularies. And without other players, other competitors, prices are going to stay high, which is not what we want. So, this is sort of antithetical to competition. And I'd love to see what the court's going to say. It has delayed ruling on this. It's still in fact-finding mode. But I am watching closely on that litigation. So eliminating rebates would be a great thing. But it's sort of a whack-a-mole situation. Like if you take out rebates here, then maybe discounts go up over here. So it's an issue that we're going to have to be wrestling with into the future. I just think that that policy could be a step in the right direction. I know that the PBMs are saying, well, it's going to drive up premiums for the elderly and for Medicare patients, and that's taboo. And so the first time that was introduced by the Trump administration, it was defeated. Because of that reason, because there was a fear of raising premiums and that it would increase federal spending somehow and out of pocket for seniors. So that's an issue, that's an obstacle that we contend with, and I think it's stemming directly from the consolidation of buyers. If I can go to 6 or 7 buyers, and there's not going to be the same leverage over me as the manufacturer, but that is not the case today. So you look at the other executive orders, and I think, as I said, these are all pretty accurate reflections of political sentiments that are out there in Congress, in the states, and in the minds of regulators. The facilitating importation, the administration just came out this week with their rule on importation, which says, we will allow importation of products from Canada, or we'll allow manufacturers to bringing their products under a different code where they make that product in the same facility as the one approved for the US. From my perspective, I don't think importation is a feasible way of lowering drug prices. If you look at a report out of Vermont that did this about a year or two ago, they didn't save money. And here's why I think that is, because generic prices in the United States are low. They're commodity prices. They're driven low by competition. And that's the beauty of the founding statute of our industry, which is the Hatch-Waxman Act. It encourages competition like nowhere else. And that encourages low prices. So importation, I don't see as if you add in the cost of what it's going to take to get medicines from Canada to here, the difference between their generics and our generics, I don't think is going to be that overwhelming. On the brand side, maybe so. But the other issue here is there's a lot of attention given to the quality of medicines, and FDA is sort of the gold standard for quality and for safety and effectiveness. And they've always said, back at least 2 decades, we cannot guarantee the safety of products that come in from other countries, Canada or wherever, that we haven't approved, products that we haven't approved. I mean, an FDA, I think, had, its gold standard was it is in jeopardy, or it is jeopardized by the idea that we could have competing products in this country that are not approved by FDA. And so the whole importation idea, I think, is problematic for that reason. That doesn't mean the policymakers aren't going to talk about it and use it as political device, but I don't think it is a real feasible way of helping public health in this country on a large scale. Anyway, there was an executive order about discounting the price of insulin and epinephrine. I think those are two. Now, Lupin doesn't have a stake in this, but I think those are two products that resonate with the public. I mean, I know my daughter has allergies. She needs an EpiPen, and they're expensive, too expensive. And the price increases were egregious, and that this was given attention by Congress. There were congressional hearings, and there are competing products out there. But and there are also now competing products for insulin out there, and they're running into the same uptake problems that I just mentioned about rebate traps and uptake in early generic competition. The other major policy that's reflected in those executive orders comes out the international reference pricing. This is an existential threat to the brand industry and, in some ways, the generic industry as well, because our prices are priced off of what the brand price was. If you have to start competing with other countries where there are single buyers, the government, naturally those prices are going to be lower. We're talking about countries that have price controls. The United States has the vast majority of the United States pharmaceutical market does not have price controls. And so if you start to bring in price controls, sort of import price controls, that's going to really erode the incentive to do business in the U.S. So it's hard to say what in the international pricing reference or international reference pricing will do, but the proposal would suggest that that Medicare would reimburse at the lowest price among a certain group of countries. The Trump administration tried to do this about a year ago, and when they came out, it was focusing on the top 20 products in Medicare, the top 20 highest cost products in Medicare. It was going to be half the country, and it was going to be an average of those prices among a certain group of countries. The executive order goes further and actually says the lowest price among those countries. And this is we're talking about for the Medicare market. But I know that there are well-founded fears and concerns that seeps out into commercial markets as well, that idea. And so that's another big issue. I think that the generic industry is going to sort of get behind. I think it's a battle that pharma is going to fight, and and we can be we probably have bigger issues to contend with than that. But that will be playing out in the next 6 months, 6 to 12 months. And then the last thing from the executive orders, the Buy American order. So this will be, there's already Buy American policy out there. It's a popular policy right now. But Buy American basically means if your government is going to procure medicine or medical devices, any of those medicines that are made in the United States are going to have a leg up. They'll have an advantage. And it's complicated by how country of origin is defined. So prior to a court case that I'll mention, the Customs Border Patrol interpretation of country of origin was, where is the active pharmaceutical ingredient manufactured? So if your active pharmaceutical ingredient, maybe it's the active ingredient, you bring it to your facility in Italy or in India or wherever, Canada, and you mix it with the inactive ingredients, the buffers, intermediates, and that's your finished dosage. So FDA's interpretation of country of origin, in contrast, was country of origin is where the finished dosage is manufactured. So there was a split between the two agencies in how to interpret country of origin. So that's important when you're saying Buy American, because if you finished your product in the United States, but your active pharmaceutical ingredient was from another country, for Customs and Border Patrol purposes, you'd be considered a foreign product, not the U.S. made product. The Acetris decision in the federal court recently came out and said FDA's interpretation is correct. They blessed FDA's interpretation that it's where the finished dosage is made, because it goes through a substantive change, which is a part of how country of origin is defined. And if you think about it, that it just makes sense from a rational standpoint. Active pharmaceutical ingredients, say, is a barrel of white powder that no patient will ever touch. And it would be toxic even if anyone touches it. It's highly controlled, versus a pill that is, small and swallowable and delivered to patients all the time. So absolutely a substantive change from my point of view, and also from the court's point of view in this case, and FDA. But that's another issue that's going to play out in the next few months with Buy American and how that's going to be interpreted. And I believe it's being looked at by the administration as your API has to also be from the US. And right now, our government is trying to incentivize active pharmaceutical ingredient manufacturing in the US. So our industry is now responding to that. The Congress came out with funding for repatriating manufacturing to the U.S., and BARDA has been allocating that funding to a bunch of companies. You've probably heard about the Flow contract, which came as a bit of a shock, I think, to our industry, because Flow doesn't have any products or approved applications or a facility, but they are selling on, I think, what has sort of been this idea, which is advanced manufacturing or continuous manufacturing, which is more efficient than batch manufacturing. So vast majority of medicines today are made through batch manufacturing. Advanced manufacturing or continuous manufacturing is meaning a continuous flow of that product, which means you have to have a continuous demand for that product. And it doesn't mean you're going to be taking those machines, cleaning them, using them to make other medicines 6 months from now, and then you'll switch it again, which is kind of how things work in the industry right now. It would be a dedicated line to that particular medicine or that particular active pharmaceutical ingredient. The US likes this, FDA likes this. I don't think they've grasped the fact that you got to walk before you run. The pharmaceutical manufacturing infrastructure in the US is not close to advanced manufacturing. Everything is pretty much still done in batch manufacturing. There's a few companies that are manufacturing a few products using continuous manufacturing. So yes, it's something that we could reach 10 years from now, but we as a world are reliant on batch manufacturing for the very large majority. That doesn't mean we can't shift. In fact, I think there are companies right now that are working to implement continuous manufacturing to sort of satisfy that desire by the government. So a lot of things are happening, a lot of shifting right now. I said the executive orders, you've got the rebates, you've got importation, you've got international reference pricing, you've got Buy American. All of these things are going to impact and challenge our industry to remain doing business here in the U.S. And then I want to switch to trade because all of the roads sort of are leading there at the moment. India and the U.S. are talking about a trade agreement. We don't know what's going to happen with that post-election. It was a small scope agreement, but it promises better trade relations between India and the U.S., which were a little shaky there for a while. But on trade, it's important, I think, to go back and look at the history of modern trade policy in the U.S. The Trans-Pacific Partnership was negotiated over at least 7 years that I was involved. I remember participating in 11 rounds, and the battleground for our industry was on intellectual property, and it was really pitting the generic industry against the brand pharmaceutical industry. The brand pharmaceutical industry wanted a high degree of intellectual property protection. The generic industry wanted a balance with competitive incentives. So in the U.S., Hatch-Waxman passes in 1984. Senator Hatch, Congressman Waxman come to an agreement that would provide patent extensions for brand products, also give exclusivity for new chemical entities to incentivize innovation, and exclusivity for new uses of medicine. So where you've researched a medicine that may be prescribed for hypertension, it also treats migraines, I get 3 years of exclusivity on the migraine indication, for example. So those are some benefits that came out of Hatch-Waxman for the brand side. For the generic side, we got abbreviated drug applications where generics don't have to repeat all the clinical studies that the brand had to do. They can just show that they're bioequivalent, meaning that the active ingredient is getting into the blood of the patient at the same rate and extent of absorption. Once the medicine's in the body, it doesn't matter whether it was generic or brand, it's identical and acts identical. And so that was the fundamental underlying scientific principle behind bioequivalence testing and generic medicines. And we also got 180-day exclusivity, which is a huge incentive for our industry, and really is why we, what the industry that we know today is attributable to that. Is what I'm trying to say. That 180-day exclusivity is a huge incentive for generic manufacturers to go after, because they can benefit from being the only generic on the market for 6 months, usually. What we have, that's really been watered down quite a bit, because you'll have shared exclusivity. When a blockbuster product is coming off patent, you're going to have a bunch of generic companies that get into the game, that challenge the patent, that have applications ready for approval. And when you're talking about 19 competitors, the incentive to get into that market is also reduced. But nevertheless, it is what drives generic business in this industry, and it drives it in a good way, because it's up the value chain. Sort of like we didn't have competing products for inhalant medicines in this country until very recently. Mylan and Teva came out with theirs. We just came out with our generic inhalant albuterol, Lupin. Now you do have competition in the inhalant product sphere, but for a long, long time you didn't. I'm getting a little bit into the weeds here. So getting back to Hatch-Waxman. So the two benefits, both sides benefit, and that leads to the golden age of innovation in the United States and the most robust generic industry in the world. So the negotiation within the trade policy was to keep that balance. And what we saw in the Trans-Pacific Partnership in the early text were provisions that would say, okay, country party to this agreement, you must provide patent extension. You must provide exclusivity. You must provide exclusivity for new indications. You must have patent linkage, which is a whole nother issue. Patent linkage, I'm going to try to give you a very simple explanation here. Patent linkage is two components. It is notice and it is injunction. The notice says you, generic manufacturer, must give notice if you're going to apply for an abbreviated application for this product. You must notify the brand, the maker of the brand product. Once the generic manufacturer does that, the brand company has 45 days to say, I'm going to sue for infringement. Now I get an automatic injunction. 30 months, that generic medicine cannot be approved for 30 months. And the 30 months comes from about the amount of time it was estimated for intellectual property disputes to resolve. But in the meantime, like no other industry, we have an automatic injunction where you haven't heard that argument on the merits. It's statutory, automatic. So very solid benefit for the brand companies. So that was a balance that it was only half included in the Trans-Pacific Partnership. So, for example, you must have patent extensions, but whereas we limit that in the United States to 1 per product or maximum 5 years or cap it at 14 years of marketing, none of those limits were in the trade agreement policy. None of those limits were in the text. There were also issues with how they drafted the exclusivity provisions. And here's a big one, and it's a single word, but it makes a huge difference. In US law, it says if you study your product and you come up with a new indication, like I was giving the example before, hypertension and migraines, I'm going to get 3 years of exclusivity for that indication, that use, migraines, for example, but not for the whole product. If the whole product has gone generic, it's been out there on the market, and a generic was introduced that can competitively treat for hypertension, but the generic can't be dispensed for that other indication with the exclusivity. So the exclusivity applies to the use. The switch that happened in the Trans-Pacific Partnership text was from the word use to product. So 3 years exclusivity applied to the use, generic can still compete for the other off-patent uses. Exclusivity for the product means you just got 3 more years of exclusivity for the entire product across the board because you added a new indication. That is not consistent with US law. And I was in conversations with USTR where I would point directly to that. And I always loved that example because it was so straightforward. And they, oh, well, so why did you put this in there? Well, because bio asked us to. Bio asked, I couldn't believe my ears. You can't pick winners and losers. You're the government. You're supposed to be objective here. Anyway, we contended with the TPP for a long time. We went to educate all of the other negotiators and said, this is what the US is going to ask you for. This is what is in US law. And this is what you should push back and ask for as well. And that held up those negotiations. And it got to the point where I may be editorializing a little bit here, but when that got to Senator Hatch's committee, the Judiciary Committee in Congress, Senator Hatch said, I'm not going to let this agreement get through my committee without 12 years of exclusivity for biologics being included there. And that was a compromise that the other countries were not going to make because they would have all had to go back and change their public health programs. And for any politician doing that at the time, it would have been political suicide. So that was a non-starter for the other parties to the agreement. And it was a non-starter for at least a handful of those countries. And it didn't strike any balance whatsoever in terms of trying to balance innovation and access or competition. And so fortunately, and sort of ironically, that was negotiated under the Obama administration. And because Senator Hatch held that agreement up, the presidency changed. And President Trump came in and he said, I don't like Obama's policy. And we pulled out of the Trans-Pacific Partnership. And for the generic industry, this was great because we weren't going to end up with this entirely skewed policy that was consistent with US law insofar as, yes, we have patent extensions, but totally inconsistent with US law insofar as there are no limits that are mandated under this agreement. I'm just giving that as an example. And And so they started negotiating the USMCA, and there's a lot less leakage out of that negotiation. We used to see those negotiating texts pretty soon after they would be shared by government to government when we were dealing with the Trans-Pacific Partnership. The USMCA, they were really tight-lipped. We didn't see the text for a long time, and when it came out, it was basically the brand company's wish list. And it was, in my opinion, a terrible policy. It was even worse than what we saw in the Trans-Pacific Partnership. But because the House of Representatives was in the hands of Democrats, and because our trade association and people representing this industry went to the Hill and educated them on trade policy, and went to the Democrats in the House and said, you know, these are public health issues, these are public health priorities, Democrats were able to get our provisions into the USMCA, which is now signed and which is now viewed as the current standard for trade agreements. And so this is a huge success for our industry. There are some provisions in there that I might change if I was king for a day, but overall it was a resounding victory for and that's a rare thing you can say in the generic industry. I can honestly count on one hand the number of those kind of victories we've had as an industry. So that was a huge shift in trade policy, and now you have USTR saying, look, a trade agreement that won't pass Congress is not a good trade agreement. And you have members of Congress saying it's not going to pass, that USMCA is the template. UK negotiators have said they agree with the USMCA. Now, the brand industry, I think they were being short-sighted when the Trans-Pacific Partnership was pending. They could have locked that down if they had given in on the number of years of exclusivity for biosimilar or for biologics. But they were staunch and they resisted, and strangely, the way politics went, generics ended up pulling victory out of the jaws of defeat on that. So that's my perspective on trade policy. I think it's in the best place it's ever been, and that the generic industry needs to continue promoting those policies as being more balanced and promoting public health, competition, and innovation. All right, I'm going to stop there. I think I want to leave some time for questions. And Sri, hand the microphone back to you. Hello, I can't hear anyone else. Hopefully I'm connected.
Yeah, I'm sorry, I missed it, Mr. Braun. What is it that you're looking for?
I just finished what I was having to say and was offering to answer any questions. That's all.
Oh, okay. So you will find some questions in the Q&A section.
Okay. Oh, okay. If new indication is added, will it restrict filling of... for some reason, I'm not... Could you read me the question? I'm not able to get the whole thing.
Okay, I'll read the question. Okay, so...
Something about the new indication issue.
Yeah, it's written, if a new indication is added, will it restrict filing of generic application even for old indication or not?
No, it would not. It would only restrict application for that that indication that you studied. You did studies that were essential to the approval of a second indication. And so if you're the generic competitor and you want to challenge a patent or bring a product to market that would be indicated for the early or the first indication, you're allowed to do that in the United States. And what I was saying earlier is that the way the Trans-Pacific Partnership text and then the early USMCA text had it would have been applied to the product across the board, very much unlike the US. So it was a bit of a power grab, in my opinion, but that failed. So generic manufacturers are able to submit applications for the off-patent, off-exclusivity indication.
Okay. I request all panelists, in case all attendees, in case you have any questions, you please type in the Q&A section or the chat box, or you would like to ask, you can raise your hand. We have some time. Mr. Brown's presentation is till 7:30, so we have another 40 minutes time.
Now I can see the questions, so let me just take a stab at this. Is it possible for... Okay. A good book that will help understand the legal policy issues faced by the generics U.S. market. Yeah, I love that question because that was a question I used to ask, and there isn't a book like that. I would go on FDA's website. It's got a ton of information. You could really give yourself a 101 looking through the policy papers on the the Office of Generic Drugs section. I wish there was a book. I remember feeling like there should be. And I advise people in my industry. So I've made, and the people that I've hired in my time in this industry, or anyone that I've given this advice to, read the Hatch-Waxman Law. Read the Hatch-Waxman Law. It's boring, but but it would really give you kind of the parameters of the founding statute of our industry, and it helps you understand, I think, how all of these other issues play out. If a drug goes into orphan before off patent, can you apply? You cannot apply for a if there has an orphan indication and it's obtained orphan drug exclusivity. No, you cannot apply for an ANDA during that period. I'm sorry, you could apply. So there's a nuance of difference between market exclusivity and data exclusivity. So what we actually have in the US, for example, new chemical entities, we say gets 5 years exclusivity. What that is, in fact, is 4 years of data exclusivity plus 1 year of market exclusivity. So in the 4th year of that exclusivity, a generic applicant can apply for approval of their generic product, but it can't be approved until after that 5th year of exclusivity has expired. And that is all the questions I see.
Yeah, there's also someone written, you had pointed on less competition or inhalation dosage form. Is this because of co-pay rebates by the brand, which leads to less generic competition?
Okay, so the long-standing issue with trying to get inhalant products approved in the United States was that FDA was very rigid in its position on how close your device had to match the device of the originator. It was very, very close, a very high bar, but has been, it's been achieved by Mylan, it has been achieved by Teva, and now it's been achieved by Lupin. And so you're going to see the competition in the inhalant sector, I think, increase dramatically in the next 5 years, with new products in the pipeline for all those companies, other people coming on board with being able to make it. And complex generics ought to be distinguished from commodity generics. Complex generics, say complex injectables, biosimilars, inhalant products that are harder to make. Those are really the areas where we want more competition because they're the highest priced medicines. Biologics, I mean, I can't overstate. I think it's something like, 2% of the population and 40% of what the public is paying. something like that for the expensive biologic medicines. So we need competition in the biologic sector desperately to bring those prices down. I'm hoping I answered your question there. Complex generics, we need more competition there. It means there's a higher bar, and it means there's less competition. So they're attractive targets for generic manufacturers, but they do require a long period of we have to research and develop, we have to formulate, we have to get it approved by FDA. I think it took, I may be misquoting here, but I think I've heard Mylan say it took them 10 years to develop their inhalant product. Don't quote me on that, but it's something like that. And it was a lot of money. I think they've said publicly like $1 billion to develop it. So $1 billion in 10 years is a long time to wait for competition. If you're a patient who's paying money every month for prescriptions for these kinds of prescriptions.
Yeah, the next question is, would the Trump's executive orders have any negative impact on Indian exports?
If what would have negative impact on Indian exports?
Would the Trump's executive orders?
Yeah, I think so. I mean, let's think about if Buy American policy is adopted, that will have an impact. I don't think it'll be dramatic because I think it's a small part of the portfolio. We're not talking about the commercial market, hopefully. We're talking about government procurement of medicines, but there are large contracts like the Department of Defense, Veterans Affairs. Those are large contracts. And so companies that are now dealing with government procurement contracts may be put at a disadvantage if they don't have American facilities. So it could impact, depending on your portfolio, it could have a more or less serious impact on your exports.
Yeah, the next question is, what are the type of generic settlements? Is it monetary benefits for not launching generic product in market?
Right. So this has been so patent settlements goes back a ways in our industry. Patent settlements got a lot of negative press, got a lot of negative treatment because it was basically reverse payments. That's what the Federal Trade Commission was looking at, is like, you got your generic approved, but we the brand company are gonna settle with you to say your launch is gonna be not until X date. The issue here is that, and this is the assumption that I've always tried to point out, the assumption is that I will win the litigation, right? So if I'm doing a paragraph 4, which is I'm going to get 180-day exclusivity, I want to be the first generic on the market. And I'm challenging the patent, I think I can win. Let's say I get to a point in the litigation where it's 50-50. Maybe I'll win, maybe I won't. And the brand company comes to me and says, look, we're going to settle with you. We'll give you this much money, settle this litigation, and now your launch date will be X. Maybe it's after the patent expires, or maybe it's a short time before the patent expires or something. The problem with the FTC's position here is that they assume that you're going to win that challenge. And so banning settlements with reverse payments, that's a presumption. It's based on that mistaken presumption that I'm going to win every time I challenge a patent. Well, you don't win every time you challenge a patent. You're taking a risk. And when you want to mitigate that risk, and even in the interest of conserving judicial resources, settlements should be available to you. Now, I understand the argument like, oh, well, otherwise you would have had this product on the market competing with the brand and lowering the price for the public. Well, what if I lose now, or what if I launch at risk? If I lose that litigation, I have to pay treble damages for anything I've done. If I've sold products, I'm getting sued for infringement. I don't settle. I drive it to the bitter end, and I end up losing. So if you're the corporation, you got to say, okay, I got to weigh my risk versus what I can settle right now and mitigate any loss that I might have if I were to proceed with this litigation. So that assumption that you are always going to win your paragraph 4 challenge is a huge problem with their argument. So the settlements now, though, there haven't been a lot of reverse. So there was a ruling, it's called the activist ruling. It was when I was working for activists by the Supreme Court that basically said, yes, a reverse distribution settlement can be a violation of antitrust, just can be. It doesn't say it necessarily is or isn't, but it can be. And so courts have fallen in line with that. And you have seen the number of reverse payment settlements go to almost zero. And now you have states that are bringing in patent bans, which have actually, unfortunately, have less understanding of the issue than the federal policymakers. So California has passed a law banning patent settlements, and it's being currently challenged by A&M in court. It's unfortunate. We've had the same issue in Connecticut, although they've been listening to us a little bit more about why we have concerns with banning patent settlements outright. What happened in California is the court said we didn't have, they used a standing argument, meaning we didn't have a grievance upon which relief could be granted. So until we get a poster child for this kind of reverse payment settlement that's pro-consumer, we don't have a good candidate for litigating, challenging that California law on the basis of the Commerce Clause and other legal bases too. But if California is trying to regulate transactions entirely outside the state of California, it violates our Constitution's Commerce Clause, and so we challenge it on that basis. The issue the court hinged on was that the fact that we lacked standing, so we hadn't articulated well enough our complaint, and or we didn't have the right example. So that's ongoing litigation. It'll be heard in October. We'll see how that goes. That state law. It's one that has not passed. It's a law that has not passed at the federal level, although it's been lingering out there for 10 years. Grassley-Klobuchar bill, which would ban patent settlements, hasn't passed. It's out there. We're always contending with that. I think in general, my opinion there is that you leave litigants the rights they have to every litigant, should be available to every litigant, the right to settle. So that's my answer there.
Next question is, this is from Sunita Sridharan. She is asking, you mentioned country of origin case. May I request you to give us the name of the case in which the issue was decided?
Yep, it's Acetris. It's ACETRIS. Acetris. I'll send it to you, Sri. I have actually on my screen here, so I can send that to you. Acetris. It's the Acetris decision at the Federal Circuit.
Okay, and now the next question is from Dr. Vishal Rajgarhia. He's asking if ANDA is filed in 4th year and patent holder acquires orphan drug status before 5th year, what will be the scenario?
Well, for that indication, at least, you would not be able to compete. That's what exclusivity is. So if they were to achieve, the brand company were to achieve orphan drug exclusivity, 7 years. But orphan drug exclusivity can be challenged and broken, and so that isn't ironclad like the new chemical entity exclusivity is. If an ANDA is filed in the 4th year, patent holder requires 5th year. Yeah, I believe you would be limited from competing in that case if a drug obtains orphan drug status. But again, it's on the indication. So if they got orphan drug status on one indication, but there are 2 indications for the drug, and that second one may or may not be off patent, but you would have the ability to challenge, get approval, and compete on that indication. And as you know, orphan drug indication is less than 200,000 cases in the United States a year, I believe. That's the criteria.
And now, Mr. Rakesh Chandara, he would like to ask a question, so I'm unmuting him. Yeah, Mr. Rakesh, you can ask the question now.
Hello, am I audible?
Hello.
Yeah. Yes, you are.
Yeah. Hello, Mr. Brown. Good morning.
Hello.
Yeah, hope you're doing well.
Thank you.
Yeah, so I have one repeat question to gain more clarity. You just spoke about the ITC and the repercussions thereon and other things. So I just would like to understand is, does ITC turn out to be a alternate and parallel dispute resolution forum? That is one question. So in case if the injunction is denied to the brand company, can they still go and stop you at ITC in case you decide to launch at risk?
Okay, you're talking about maybe inter partes review?
No, ITC, International Trade Commission.
Oh, okay. Sorry, I don't know about the International Trade Commission issue.
No, so or maybe if it is called as Federal Trade Commission, in US it would be more to where a brand company can stop you from importing something infringing. So if a parallel court dispute is going on where the court denies an injunction to the brand company and the generic decides to launch at risk, still FTC can turn out to be a alternate and a parallel forum where they can stop you? That is my question.
I'm not familiar. I'm sorry. It sounds like they would be able to put up a trade barrier sort of to you being able to import your product because it would be infringing, maybe. But if the court has ruled that the generic is not infringing, I'm not familiar with the second way of stopping the generic competitor. If you're found to not have infringed, you might be on appeal to the appeals court, and therefore at risk that if the appeals court may overturn the ruling. You can launch at risk, or you can seek a declaratory judgment. But I'm not sure where the ITC enters into that. I'm sorry, I don't know.
Okay. So the theme that comes from is like often, though I come from a biosimilar domain, biologics, I'm a little bit familiar with Hatch-Waxman also, and where the court disputes and all happen often at times injunctions are denied to the brand company only on the premise that these are not an irreparable damage or harm. They can be very well calculated and compensated for also. So, but then again, there is a trade commission forum that is there, which so one case that is going on between Regeneron and Roche, where they had filed a complaint at the trade commission to stop the generic from importing the infringing issue. So it was more pertaining to on those lines actually. Okay, so fine. The second, then it will be answerable in the absence of the first one. So in case if at the trade commission, brand succeeds in stopping the import, but overall they lose at the court and they are unable to assert their patent and all, is there any kind of reverse compensation or reverse damages that would be paid to generic for not being allowed to do the business during that period?
No, there ought to be, but there isn't. In fact, we've tried to put that into some trade policy before. Sort of like, okay, if your 30-month injunction stopped what would otherwise be an approved and not infringing product, shouldn't the brand industry disgorge some of its profits that it was making during that time? But that isn't, we've never gotten that policy through anywhere, and certainly not in the U.S. or into any trade policy. But it's been discussed because, as I said, I mean, the Hatch-Waxman issue is that you don't have to make your case on the merits. You just say, I'm suing you for infringement. Maybe it's a meritless lawsuit, but I still get 30 months just because I sued. And so that's a kind of a philosophical problem I have with that, is that it's too easy. There's no hearing on the merits of the patent owner. And in other industries and in other countries, you don't have that kind of protection. You know, we're talking about the software industry. If a software company sues another software company, there's nobody saying, "Oh, well, we're not going to give you marketing approval on that product until you have proven that you're not infringing." That's only unique to the pharmaceutical industry.
Okay. Thank you.
The ITC question, I can find out more for you if you want to take it offline at some point. I can ask some people who would probably know better than me. I hadn't heard about that. I hadn't heard about using ITC to limit competition that way.
So there is one case currently going on where Regeneron is trying to import into US a pre-filled syringe which is infringing Novartis patent. So they have filed a complaint with the Trade Commission so as to stop the Regeneron from importing them. And that is where actually the scenario is. So if in BPCI, if you see, where if you have filed for marketing approval where you are supposed to inform the brand that we have filed, and then they have a different patent dispute resolution forum where they are supposed to do the patent dance, where the district court or the court this thing is pending, the case is pending. But alongside, if suppose they get approval by the FDA, or if they are issuing a notice of commercial marketing, the brand again brings in a motion to get a preliminary injunction. So on many of the instances, it has been observed that court denies the injunction mainly to favor or encourage the biosimilars to enter only on the premise that, okay, the damage is calculable. So you're not incurring any irreparable harm. Whatever profits you would be losing, you would be getting compensated for in case you win the dispute. So in that case, if they lose the injunction at that point, still the Trade Commission, I mean, the question was only that still they can bring in a complaint at the Trade Commission and stop the import. That was, okay. And this becomes more important from Indian point of view or any other foreign country point of view.
No, you're educating me. I hadn't heard about this, but I feel like I should know this. So I'm going to look into it. And I think anyway, my name is Shawn Brown, SHAWN, Brown like the color, @lupin.com. Send me an email and I will find the answer to that question.
Definitely, I'll drop you an email.
Okay.
Yeah. There's two more questions actually. Two more questions. Next question is from Mr. Satish Kumar. He's asking, does any generic pharma company can make any profit as a FTF filer with more than 20 players filed on same day like Apixaban, etc.?
Yeah, that's another great question. I think it's one that all generic manufacturers are asking themselves. I think there was a statin that came off patent. It was like 19 competitors jump on. So you have to look at, do you have it's a business thing, you're competing. So you have a portfolio of products and you include this in your portfolio. I don't know if they can make money. Not all generic products make money. Some lose money, but they're maintained in a company's portfolio because patients need it and wholesalers are buying it, even if it is at a loss. You keep it there to make your portfolio more robust. But can companies make money when there's 19 competitors? Probably not. I think it's a pretty narrow margin. Sometimes anyway, and then on top of that, the price is going to drop precipitously when that many competitors come aboard. But I think if you look at those charts, you usually get like a spike in competitors, and like I said, because of consolidation of buyers, they have so much leverage. They're going to take who can give it to me the cheapest. Reliability of supply is a factor, and if you have companies that have less wherewithal to deliver consistently, then you'll have companies like the top generic companies that are able to outcompete those smaller companies who maybe don't have as reliable a supply chain. But like I was talking about earlier, there's that price harmonization when there's consolidation in the buying groups. And if you aren't doing business with one of them, you're not able to do business. So 19 competitors is not viable in the US. Maybe even 6 isn't viable, but because you have a monopsony, a limited number of buyers. So yeah, I think it would be, you'd have to be a pretty savvy business person to be able to make money in that kind of environment. And so it's a lot of staunch competition in the generic industry in the US, which ends up favoring the public really by driving prices down. But like I said, it can go too far where you have, Gottlieb's list of, whatever it is, 200 products or something that are off patent, off exclusivity that nobody wants to make because there's no money in it for them. It didn't used to be like that.
Okay, the next question is grandfathered drugs are sold in US market as an unapproved drug. Is Indian pharma companies can export any unapproved drug without FDA approval to sell in USA?
So maybe drugs that have gone through the DESI process. Yeah, there are unapproved drugs, but at this point, I think FDA is really pushing for all products to have safety and effectiveness data. There are some products that are, old products that have been around a long time. Some of them are used every day in hospitals, and they're sort of grandfathered through. So companies can then go ahead and apply for an ANDA or apply for, say, a 505(b)(2) for some of those products. But it's not too many. There aren't many of those products. It's a small category. So no, I mean, I think for the majority products, safety and effectiveness has to be established. And then for those other products that are out there that are sort of grandfathered, like pre-1962 products, sometimes the status of those products is threatened by FDA's insistence on having safety and effectiveness for each of those medicines, because some of those medicines are really important for emergency medical use, for example. And so you can't just ban those products because they're needed for a medical necessity. So that's my answer. I think you'd have to look at a very small group of products that don't have FDA approval necessarily, but are still used because of that.
Okay, we still have 15 minutes and the next speaker has not yet joined. We have 2 more speakers today. One is Mr. Jeff Francer. He is the Senior Vice President and General Counsel at Association for Accessible Medicines. He is going to discuss on key issues Indian generics face in the US. And then we have Dr. Krishna Ella. He is the CEO of Bharat Biotech. He is going to speak on the issues that Indian pharmaceuticals face, especially in biologics research. Their sessions would be starting at 7:30, so we have 15 more minutes. So I'd request participants to, please ask questions so that, yeah, there is one question from Ms. Aradhana Sadashivam. She's asking, are there different standards for testing non-antibiotic and antibiotic drugs? Mr. Brown?
On mute. Yeah, different standards for testing antibiotic and non-antibiotic drugs. I mean, the standard is always safety and effectiveness. If you establish that, and quality, you have to go through the same FDA procedures. So at that level, I don't say there is not a different standard. I mean, if you get down into the science, I'm sure, they probably go to different scientists at FDA for approval, but I'm not sure if I'm answering your question, but there is no different standard. Standard is always safe and effective, a bioequivalent if we're talking about a generic product. Or, you have to have the clinical research if you're talking about a brand product. So no, there is no different standard.
Okay. So if any participant would like to ask a question, please raise your hand. We still have 10 more minutes before we have the next speaker joining. Are there any more questions? Would anyone like to ask any question? Yeah, I think, Ms. Brown, I think there's no one asking any more questions.
Okay.
So if you would like to say something,
Yeah. Thank you. I didn't get a chance to get into sort of what's going on immediately in the legislative sphere, and I think maybe Jeff will get into that. So I don't want to preempt his talk, but we are very concerned about. Well, we talked a lot about Hatch-Waxman today, and we're very concerned about what Congress is currently considering doing to the Hatch-Waxman Act. It's called the Blocking Act. I think Jeff will probably elaborate on this, but the Blocking Act came out last year, and the idea was that policymakers believed that the generic companies were getting all but approved, and they would get their 180-day exclusivity, and then they would sit on their exclusivity, because your exclusivity starts the day you go to market. There is a forfeiture provision in the law that says if you don't go to market within 75 days of marketing approval, you forfeit your 180-day exclusivity. So we've kind of described this as a solution in search of a problem, because we don't think there is a big problem with what they call blocking. So they're alleging that that first filer is sitting on their application and not letting other competitors who would otherwise be ready to go to market enter the market because they've got some settlement with the brand company or any number of reasons. There are a lot of reasons why companies that have marketing approval don't necessarily launch their product. Could be a lot of different things. I've given the example that Lupin once had an ophthalmic product that we had gotten it approved by FDA. FDA said, kind of late in the going, that the little plastic rings when you undo a bottle that's sitting there, that was falling off the bottle when they were dropping into the eye. So Lupin had to change the packaging. So the packaging delayed us past, say, 30 months from when we had submitted our application. In that case, currently that's okay, but what the Blocking Act would do is would allow subsequent filers to trigger your 180-day exclusivity before you're ready necessarily. And so what we're saying is, like, look, that really reduces the incentive for us to challenge these patents, for us to look at all these brand products that are coming off patent or close to coming off patent that we feel are candidates for challenging and for formulating our own and submitting an ANDA for. Yeah, so
I think there's one more question.
The Blocking Act is gonna it hasn't passed into law, but it's out there and it's threatening that incentive. And we've had, as an industry, kind of a little bit of consternation, because on one hand you have policymakers out there saying we really want manufacturing in the US, we want more infrastructure here, we want everyone to be onshoring and build up this domestic capacity. And on the other hand, you're taking our best incentive to do business in this country and to challenge the patents of brand products and bring products to market early and watering it down. So, you're giving with one hand, you're taking away with the other. Well, the first thing you can do, policymakers, is do no harm. do not harm my incentive to challenge a patent or bring a product to market earlier than patent expiry.
Yeah,
So that's
there's one more question from Mr. Satish Kumar. He is asking, could you please throw some light over brand copay /rebate /bundling to avoid generic competition?
Yeah, I think that's a huge thing in my opinion. The bundling and the rebate trap is a riddle that we need to solve as a society, not just as an industry, because what's happening right now with that J&J versus Pfizer litigation is a cautionary tale. If I'm Pfizer, I've got, put Pfizer up against any other generic company or any other company. Generally, Pfizer is a huge company. They have lots of resources, lots of intelligent people working for them, lawyers. They cracked the code. They got a biosimilar, infliximab. They go to market, and there hasn't been uptake for this product because J&J is blocking them from the formulary. J&J is saying, all of the products I sell to you, PBM, that I pay you rebates on, those rebates are now bundled together, and I'm going to use those as leverage. If you don't give my biologic product exclusivity on your formulary, and you let infliximab, my competing product, on there, I'm going to take away all my rebates. And J&J's argument is, Pfizer, you're not discounting your product enough. You didn't cut your price enough. You're not competitive enough. Pfizer's argument is that I can't break into the formulary if I'm blocked by this anti-competitive behavior. And so they alleged violation of antitrust, and the court did not dismiss that claim. So now it will be heard on the merits. But this is a story that you can apply across the board. It's all the products that you have generic products that are the first generics of a brand, a competing brand product, and they aren't getting picked up on formularies for years because PBMs don't want to let go of a revenue stream that they're getting from these high cost drugs because they're sharing in the profits that the brand makes. This seems pretty messed up to me. I mean, that you're sort of paying off the formulary people to keep the competitor off. It's not helping the public. It's helping to the insurer plan that's hired the PBM, and it's helping the brand company maintain their monopoly. So it has to be broken. I don't know what that ruling is going to be, but it'll be huge because if J&J wins, every brand company out there with a biologic takes that and puts it into their playbook. I'm going to bundle my rebates. I'm not going to let anybody into this formulary. If Pfizer wins, then we have a fighting chance. We the biosimilar industry, have a fighting chance to get in there. Look at the uptake in Europe. I mean, the EU biosimilar uptake has been substantial, and it really the expectations of the biosimilar industry in the U.S. fell far short of where people had expected it, where a CBO had scored it. They're projecting tens of billions. Well, they didn't listen to the industry, and we ended up, falling prey to litigation delays. You have, I think recently, actually Amgen, there was a Pfizer citizens petition calling out Amgen for all of their negative rhetoric about biosimilars and calling biosimilars less safe, risky, and all these other things. Biosimilars have to have the same clinical effect, identical. So, and then, ask a brand company, does one batch of your biologic vary from the next batch of your biologic? And we're talking about living cells, huge living cells, and the primary, secondary, tertiary chains are all identical. Chemical chains are all identical, but there's some heterogeneity, or what is it called? Yeah, heterogeneity or something like heteromicrogeneity, where there's some variance from one cell to the next. Nothing that would have a clinical impact, but you can't say that a biosimilar is the exact copy of a biologic product. But just like a brand company can't say, this biologic is an exact copy of the next batch that I'm going to make, that I don't need to go through any additional regulatory hoops to get onto the market. So if you've undertaken the investment to get a biosimilar through the approval process, you've done clinical studies, you've shown how it's characterized down to a molecular level, you can do all those things. We have the same technology that the brand industry does, and that really supports a safe and effective approval. So, who benefits from arguing that biosimilars are not as good? Well, the brand, of course. So there's a lot of, we have an uphill battle in terms of the perception, and we also have the legal challenges, and we have the, I guess, regulatory challenges or business challenges of bundled rebates. And we're going to see if we can get past that hurdle when the court rules, hopefully, on that Pfizer J&J decision.
Okay, I think we are done with the questions. No more questions. I don't find. Okay, someone has asked a question. Okay. Yeah, Ms. Aradhana Sadasivam, she is asking, maybe you would like to ask the question yourself, Dr. Sadasivam. I'm just unmuting you.
Hello, Mr. Brown.
Yeah.
Hello.
Hello, I'm working on a non-antibiotic drug for bovine mastitis. So I would like to inquire whether there is a separate regulation for non-antibiotics as compared to antibiotics in US or other countries.
Is this a veterinary medicine?
Yes.
Okay. I'm out of my depth on that. I'm sorry. I'm not sure.
Oh, all right. Okay, thank you. Thanks. No worries. Thank you.
Sorry.
Okay. Thank you, Mr. Sean Brown. Thank you very much.
Thank you. I love this. Thank you so much. Thank you for listening. I hope it was interesting.
It was. And we have our next speaker, Mr. Jeffrey Francis. He has just joined. Just a moment. Yeah, Mr. Francis, I made you a presenter. In case you would like to use a presentation, you can, share the slides now. Yeah, we are able to see that. Kindly put it in the slideshow mode so that it goes to full screen. And I think you are on mute. We're not able to hear you. We are not able to hear you, Mr. Francis. Looks like you're on mute. Yeah, it's. Yeah, this is good now. Can you? But we are not able to hear you. Good evening, Dr. Krishna Ella. Thank you for joining. We have the presentation of Mr. Jeffrey Francer, and then your address. Not able to hear you.
Can you hear me, my voice?
Yeah, we can hear you, Dr. Ella.
Thank you. Thank you very much.
Can you hear me now?
Yeah, we can hear you. We can hear you. Please go ahead. Thank you.
The phone, no problem, and apologize for the technical difficulties. So now I'm trying to get back to the screen with my slides on it, which I can't see right now. Okay, so people can see me, hear me, and see the slides?
Yeah, but if you can put the slides in slideshow mode, it'll be we'll be able to see a larger screen.
Okay, I'm working on that, and I apologize for all of the difficulty. It's really not cooperating this morning.
No, you're fine, Jeff. Welcome. Perhaps, Jyoti, you can become the presenter and put it on slideshow mode and then give it back to Jeff?
Yeah, but then I need the, I cannot share his slides.
Oh, I know. Jeff, go to the bottom of the PowerPoint and you have 4 icons, right? One with little squares, and then there is one more, and then the last one like a little bucket, like a cup. Just go and click that, and that should put you on slideshow mode.
It's on, yeah, it's on slideshow, but I think I'm sharing the wrong screen. So I have to,
Yeah, you stop sharing and then share the slideshow mode screen.
yeah, okay. I'm really sorry.
Oh, no, it's happened with all of us. Trust me.
How's that?
Yeah, that's great.
Not good?
That's good. Thank you.
Perfect.
Okay.
Welcome, Jeff.
Okay, so good morning or good evening, everybody. I think that covers everybody who's on. So my name is Jeff Francer. I'm the General Counsel of the Association for Accessible Medicines, which is the trade association for generic and biosimilar manufacturers here in the United States. Great to be with you, and thank you for listening on a Sunday. I am, I'm trying to figure out how to get, there we go. So what I wanted to discuss this morning, and obviously looking forward to a dialogue and questions and discussion, are the value proposition of generics and biosimilars in the United States, a quick overview of the US market, and then some of the headwinds that we are experiencing right now. Some of this has to do with patent thickets, which I'm sure you've discussed already. Some of it has to do with the 180-day exclusivity incentive for first filer generics that challenge a brand drug patent. Some of this has to do with challenges in settling patent litigation with the brand companies and new restrictions on these settlements. And then, as everybody knows, there is an increased nationalism really around the world, but even here in the United States. And there is great pressures for pharmaceuticals that are used in the U.S. to be made in the U.S., and that's coming from Washington right now. And we're going to talk about some of what's been proposed and some of and how we have responded as a trade association. So first, I'm going to show you. This is the cover of our annual savings report. And as you'll see, we're titling it this year, Securing Our Access and Savings. And that's not by accident. We have great pressure here in the U.S. On two accounts. One is pressure to make drugs that are used in the United States, here in the United States, but also there's great pressure as a result of the COVID crisis to respond to weaknesses in the supply chain. So the good news with respect to COVID, if there is any good news, is that in the U.S., we have not seen significant drug shortages as a result of the pandemic. Certainly nothing like the shortages that we've experienced with respect to PPE, like face masks, even cleaning supplies. You know, for the most part, the generic drug industry has really responded very well to the COVID crisis, and it has not been easy. And I'm sure those of you at companies outside of the U.S. Who are shipping drugs to the United States have noticed that it's been harder to get drugs here and harder to get them here at a price that you're used to paying. And so we've been working with our legislators to try to make it easier for drugs to be able to be shipped here. But it has not been easy, and we recognize the supply chain is very stretched. So here's the good news for people in the United States. The good news is that generics continue to offer enormous savings to patients in the United States. And every year, our association releases a report together with IQVIA that calculates the amount of savings that generics provide over their brand name competitors. And the savings that generics have provided to our country, which means the government paying for drugs, as well as private insurance and patients who pay for their own medicine, the savings is up to $2.2 trillion over 10 years. And in addition, in the last year, 4 billion prescriptions for generic drugs were filled, obviously several prescriptions per person. And the savings from 2019 alone was $313 billion. This is the first slide that we would show to any policymaker in the United States who wants to do anything that would damage the market for generic drugs, because this is really quite an incredible amount of savings. In particular, we're beginning to see more and more prescribing of biosimilars. And I think most of you probably know that the biosimilars pathway, the regulatory pathway in the United States, is 10 years old. And we're now up to $2.2 billion of savings in 2019. And there's an estimated amount of $4.5 billion of savings over the last 10 years. I've recently seen another number up to $6.5 billion, but there's still a long way to go. And I think it's very clear to me that the market for biosimilars is just beginning in the U.S. We have a long way to catch up to Europe, and this will be an incredible growth area, I think, over the next 10 years. We also are emphasizing the amount of work that is done on generic drugs here in the U.S. And as I mentioned, there's an increasing amount of nationalism. That isn't always the best for a global industry, and It's certainly not something that our industry wants. However, we do have to respond to concerns that say, concerns of people who say, well, how can we trust the quality of your medicine? Everything comes from somewhere else and, we know nothing about it. So we have been emphasizing really for the past few years the amount of work that's done in the U.S. And a lot of this is the finishing work, but by our estimates, more than 60 billion doses of generic drugs are manufactured in the United States every year. We've surveyed our members who have almost 150 manufacturing facilities in the U.S., employing about 52,000 people. And the FDA has data that over 50% of the FDA-regulated API facilities for drugs that are used in the U.S. are actually in the U.S. and Europe. So we also emphasize the fact that under the FDA's own data, they find no significant differences in quality for drugs that are made in the U.S. versus drugs that are made outside of the U.S. And obviously, this is an important issue here. All of the pharmaceutical industry is under pressure on quality. It's not just the generic side, it's the brand side as well. And we're trying to just respond in a very data-driven way, as is the FDA. This is a breakdown of the savings that our companies provide on a state-by-state level. And one thing that you can see is, and this isn't incredibly surprising, is that the most populous states have the most savings. So New York gets about $25 billion a year in savings from generic drugs compared to the price that brand name drugs cost. And the states are responsible for purchasing a lot of the drugs under our Medicaid program, which is the healthcare program for the poor. California has over $28 billion of savings. Texas, $23.8 billion of savings. So when we talk to legislators about policies that can harm or help generics, it's important for us to show them all of the savings that generics are providing. So now I wanted to talk about some of the challenges that we are facing. And I think it should be no surprise to the people in this meeting that one of the key areas of challenge for our companies is the increasingly large patent estates that are now protecting some of the newer brand name drugs. And there are not just the composition of matter and the method of treatment patents, which were the traditional types of patents that were protecting brand name drugs. Now you're seeing patents on the devices that are built into the generic. So the auto injectors, for example. You're seeing patents on methods of manufacturing. You're seeing patents on the formulation and even impurity profiles and pharmacokinetics and the methods of testing for the adverse events or the impurities of drugs. These types of secondary patents we see to be among the weaker patents, and that is both good and bad. They can be easier to take down as not novel. But the fact of the matter is the patent office here in the United States continues to grant these patents. And so it's a challenge for our companies, the generics and the biosimilars, to break through these patent thickets. So the case study, Exhibit A for patent thickets is Humira. And this is a drug that I think everybody has heard of. They advertise on television in the United States. They spend an incredible amount of money on advertising in the United States. And it's a drug that globally, and this is really, absolutely mind-boggling, takes in more revenue than all of the NFL football teams combined over $20 billion in annual sales. Now, that alone, I don't think is a problem. Our association values true innovation, and when Humira came to market in 2002, it was a truly innovative drug. The problem is that it's had a monopoly period since 2002, which, by my math is 18 years. No one ever thought that this drug was going to be alone on the market for 18 years. They continue to increase their prices, which is costing the patients who are on the drugs. It's costing states and cities and insurance companies. And I think a lot of policymakers, both Republicans and Democrats, have questioned how did this company keep this monopoly for so long? And one thing that is very clear when you look at the patents on Humira, and we've done an analysis of these patents, is that over 75 of the patents on the drug were applied for and granted within 3 years of the expiration of the initial compound patent. So in other words, there was an initial 20-year patent monopoly, and then over 75 of the drugs for over 75 patents, AbbVie put in applications just as the initial term was expiring. So in other words, they kind of leapfrogged the exclusivity again. Now, the latest extended potential patent life is 2034. Now, Amgen has settled its patent litigation with all the companies that challenged these patents, and we will now see competition in 2023. So biosimilars for Humira in 2023. They had competition in 2018 in Europe, and part of the reason that they had competition in Europe was a different patent system with a stronger ability to oppose the brand name drug patents. And as a result, patients in Europe have had much easier and less costly access to Humira since 2018. So we view this, and I think it's fair to say that Democrats and Republicans alike view this as a problem, this patent thicket on Humira. And we're looking for balanced ways to try to address this to make sure that this doesn't happen again. And one of the ways that some policymakers have approached this is to try to limit the amount of patents that can be litigated. And so one solution that I wanted to call your attention to, because I think there are a number of folks in the meeting from Texas, is a solution that was put forward by Senator John Cornyn, a Republican, and Senator Blumenthal from Connecticut, a Democrat. And it's very interesting when you see a bipartisan bill like this. You hear about all the polarization in the United States, and it's certainly polarized, but yet you have a prominent Republican and a prominent Democrat in the United States Senate getting together on a compromise to address this very issue of patent thickets. And so what would happen under this bill is that the brand would be able to choose 20 patents to protect and be the subject of litigation. Those are the only patents that could be used to stop biosimilar competition, and there are some exceptions, but the general rule would be no more than 20 patents to protect a biosimilar. So this is a bill that's had very widespread support. We support it at AAM. A number of stakeholders who want to see lower prescription drug prices in the United States support it. Unfortunately, the way our legislative year has shaped up, with everything concentrated on COVID and the election, and now a new Supreme Court justice, who's been nominated. I don't expect this to pass this year, but this is certainly something that we will continue to support next year and try to make it even stronger by decreasing some of the exceptions to the patent cap. Next, I want to talk about 180-day exclusivity. And I'm sure you've already talked about this policy in your during this meeting, but 180-day exclusivity is the key generic incentive to file as quickly as possible on the first day possible, and to challenge a brand drug patent as part of a compromise, because in 1984 you had another bipartisan deal. Senator Hatch, a Republican, Congressman Waxman, a Democrat, and they were the ones who invented the generic drug regulatory pathway, the ANDA pathway. And they cemented in a certain amount of exclusivity for the brand, but they also provided this critical 180-day exclusivity for the first company to market the first generic company to file and challenge a patent. Now, I think you've probably already talked about how this exclusivity works, but part of the compromise is providing transparency to both sides. So when a generic has to market its ANDA, they have to go through the brand drug patents and either say the patent has expired, or they will wait to market the drug until the patent expires, or importantly, that they believe that the patent is invalid and not infringed by its proposed generic product. If they make that certification, then there will be this 30-month stay in which the FDA is not allowed to approve the generic, and there's supposed to be patent litigation during that 30 months. So this Hatch-Waxman system is a compromise between the innovative side and the generic side. For many years, 180-day exclusivity has been the crown jewel and really critical to our industry. The problem is that the system is, I think, deteriorating over time. And let me tell you two reasons why. One is that initially when the statute was passed, there was only one first filer. The statute was changed in the 90s such that there can now be many first filers, and often there are, over 5 first filers who have to share this exclusivity. So it's not a true exclusivity if you have 5, 6, 7 companies who are able to share in that exclusivity. And we have challenges even now where there's proposed legislation that would essentially allow a subsequent filer to market and trigger the first filer's exclusivity if the first filer is not ready to market within 30 months. And so this is some legislation that we are opposing strongly. And while we don't believe it will pass this year, it's a challenge that we're looking at in future years. Second area of challenge that I want to talk about is patent settlements, and that is the ability to settle patent litigation. An issue here is Hatch-Waxman creates this incentive to challenge the brand drug patents, but at the same time, this patent litigation is extraordinarily expensive. We have seen that in general, generics have less than a 50% success rate when challenging brand drug patents. And if the generics lose, they've spent a lot of money to try to get on the market, but they're still off the market until patent expiration. So there are enormous incentives to settle this type of litigation. And, excuse me. And in 2013, the Supreme Court had put limits on the ability to settle patent litigation in a case called Activists, or FTC versus Activists. But importantly, the Supreme Court declined to hold that reverse payment settlement agreements are presumptively unlawful. And what a reverse payment settlement is anytime there's a litigation settlement that offers anything of value to the generic. And that could be the brand company will manufacture the drug. It could be a simulation of 180-day exclusivity for the settling party. So the Supreme Court has held that these types of settlements are not inherently or presumptively unlawful. However, the agreements should be carefully analyzed by the FTC and balance the benefits and the risks of each of these types of settlements. That said, we have seen legislation, including legislation that passed in the state of California, that has limited the ability of our companies to settle. And importantly, California has now called a settlement that provides anything of value, including an exclusive license, to be presumptively unlawful in the state of California. There are also questions about acceleration clauses or most favored nation clauses, which allow a settling generic to come to market if any other generic comes to market. So this is very important. We have a situation in which California has outlawed important types of settlements, and this one state, which obviously is a big state, about 1/3 of our country by GDP, is dictating the terms to the rest of the states. And so we have a legal challenge that we have brought because we don't believe that one state can dictate the national market for patent settlements in the United States, and that is brought under the Commerce Clause of the Constitution. The last topic I want to talk about is our blueprint to enhance the security of the pharmaceutical supply chain. As I mentioned before, supply chain security is a huge priority in the United States, and this has only been exacerbated by the COVID pandemic. There were over 39 bills proposed in Congress to address the pharmaceutical supply chain. Both former Vice President Biden as well as President Trump have recommended changes to the pharmaceutical supply chain, and both would change what are called the Buy America rules, which dictates the conditions upon which the government may purchase pharmaceuticals. And in particular, the Trump administration has said that they don't want the U.S. government buying drugs that are not made in the United States. And that definition, of course, can change. So what we have done is to try to devise a new system that would concentrate on essential medicines used in the United States and provide incentives rather than a penalty, rather than penalizing companies that are manufacturing pharmaceutical products around the world. We believe that we should work with our allies, which includes Europe, Canada, Mexico, India, and other countries, on a cooperative approach to free movement of pharmaceuticals, especially in a public health emergency, as well as coordinating our approach to localized manufacture. In addition, we've proposed incentives for companies that want to invest in the United States. That includes long-term contracts at a price premium in order to incentivize drugs that are made locally, as well as tax credits and grants for local manufacturing. The last point I would like to make is that some of our ideas have been picked up in an executive order that President Trump signed on August 6th. The Trump administration has endorsed the concept of concentrating on essential medicines, and the FDA is in the process of creating a list of essential medicines. However, the Trump administration has also proposed changing the definition for products that are quote unquote made in America. and they would change that definition to say that a product is not considered made in America unless the API, the key starting materials, and other ingredients are also made in the United States. That's something that, that we do not support, and we certainly don't believe that a change like this should be made in the middle of a global pandemic. Needless to say, there are many exceptions to the Trump executive order. I'm happy to talk about that in the discussion, and it would take months, if not years, to implement anyways. So I just want to close by saying it's a real privilege to speak with you all today. There's a lot going on here in the United States with respect to generic drugs and biosimilars. We have a lot of challenge, but we also have to remember that it's our companies that provide access to patients in need of affordable medicine. We have to be proud of that, and at the end of the day, our healthcare system depends on that. So look forward to the rest of the discussion, and thank you for your attention.
Thank you, Mr. Francis. Now the floor is open for questions. Requesting participants to post their questions in the chat box or the Q&A, or you can even raise your hand to ask the question. Yeah, there is a question. You want to? Okay, I'm just unmuting Mr. Rakesh. Yeah, Mr. Rakesh, you can speak now.
Hello, Mr. Jeffrey. Answer. Good morning.
Hello. Good morning.
Yeah. Yep. So I have one question regarding this Cornyn Blumenthal solution that you have talked about, which looks very interesting and very much resolving as well. The question over here is the caveat of 20 patent itself. Don't you think that this window would still be broad, and it can still encourage gamesmanship amongst the brand manufacturers by floating, where they can float newer and newer patents at any point of time during the entire product life cycle?
I'm not sure I totally understand the whole question. Are you talking about our proposal on the supply chain?
No. This is about Cornyn Blumenthal provision that you have talked about. Yeah. So where the idea that has been proposed is to have just 20 patents. That sounds really very good, and resolving one between, the dispute resolving between a brand and a generic one. But at the same time, don't you think that still 20 patents would be quite a broad window, accounting for, even if we account for all different aspects, and still it can encourage gamesmanship amongst the brand owner, where they keep floating different types of patent all throughout, throughout the product life cycle?
Yeah, so that's a great question, and I'm sorry I didn't understand you before. I had to call in on my phone, so the audio is not as good. But the answer to your question is, I agree. 20 is probably too much, and we had actually proposed 10, which is also still significant. But this is a compromise. I think it's fair to say that Senator Blumenthal, the Democrat, would have been happy with 10. The brand companies who opposed this proposal were not happy with even 20. I mean, they're not happy with this proposal at all. But 20 was viewed as a compromise. We think that this legislation can be improved, and we would like to see it brought down to 10, and also fewer exceptions to the cap. And so, it's a mixed bag, I would say. There's pluses and minuses. One of the pluses and minuses is this is not going to pass this year. So we have the opportunity to go back and try to improve it even more. But the main issue here is it's a compromise between the brands who want no limits on patents and someone like Senator Cornyn who's willing to stand up and say there has to be some limit. So I agree, it could be quite a burden to litigate even 20 patents.
Yeah. Thank you, Mr. Jeffrey.
Yeah, there is a question. What is the biggest change that you see that COVID-19 has brought to the pharma industry locally in the US as well as in international pharma landscape?
I think the biggest challenge that we've seen everywhere in the world is at the beginning of the crisis, when the United States and others needed PPE and medicine from other parts of the world, and this happened around the world, individual companies closed their borders. It didn't happen for long, and it's not permanent, but it really scared people in the United States. It triggered and I think exacerbated the nationalistic fervor that we've been seeing around the world, and that's only helped fan the flames that we see in this whole kind of Buy America, Made in America issue that we see now. And I think COVID has illustrated the need for the free flow of medical goods around the world. But also, to many people, it says that we need to have local capacity in an emergency for certain types of medicine. So, as with anything, there are pluses and minuses. With COVID, it's almost all minus. I don't want to say that anything good has come about from this, but I think it's fair to say that the focus on the supply chain has only been increased as a result of COVID.
Okay, there's another question. The question is, currently are Indian manufacturers allowed to participate on FSS procurements?
On what procurement?
FSS.
Okay, so the answer is yes. Right now, there are, so the question is, I just want to take a step back. There are many ways that drugs can be purchased in the United States, and specifically by the government. We do not have a free trade agreement between the United States and India. I know one is being discussed. But there are other ways that drugs can be procured for government use. And one of the ways is if there are significant price differences between domestically available drug and foreign available drugs. So while there is not a free trade agreement between the US and India, many Indian drugs are available for government procurement now, not as a result of the trade agreement, but as a result of price differentials. That being said, I think that there should be a free trade agreement between the US and India, something we support. And India should be there with the rest of our security allies with a free trade agreement and with easy access to the US market.
Okay, the next question is AAM leaning towards generic patent settlements with brand owners?
So is the question do we support generic settlements with the brand companies?
Maybe I can ask Mr. Satish Kumar to speak. Yeah, Mr. Satish Kumar, can you ask your question directly?
Good morning, Mr. Francer. It was a good session actually. Just I want to understand, you are talking about the point, only 50% chances are there for generic companies to win the Hatch-Waxman litigation. So based on that, just I want to put out a question that is AIM is leaning towards generic patent settlements.
So we see, I think, a mixed bag here. We do see there are still settlements. It is getting harder to settle drugs, specifically because of that California law that I mentioned. But at the end of the day, without settlements, we believe there will be less patent litigation, less challenges to these patent thickets. So we believe that there has to be the ability to settle. We believe that without settlements, we will not see competition to drugs like Humira. The only reason that we're seeing competition to Humira in the next year or so is, well, I guess in the next 2 years, is because of a patent settlement. So it's critical that our companies have the ability to settle because the success rate in our Hatch-Waxman litigation is 50% or less. So it's a risky proposition to try to beat all of the brand drug patents through litigation. I hope that answered the question.
Okay, the next question is the settlement fastens entry to market or mitigate risks, but brings penalty provision AB 824. In case of settlements, how to prevent AB 824?
So that 824 is the California law that passed. So right now, if a company is doing business in California, and it's almost impossible. I'm trying to get to the slide that talks about the law there. As a result, the state of California is asserting that they can prosecute a company anywhere in the United States for settling patent litigation that they believe is anti-competitive. So it's not even a question of is the company physically in California, and it's not even a question of is the drug sold in California. They believe that as long as a patient in California can access that drug, if there is a settlement, so for example, through a pharmacy, as long as a patient can access that drug, the state of California believes that they have jurisdiction anywhere in the United States. We believe that this is wrong. We're challenging it. But I don't know how, for any drugs sold in the United States, I don't know how you can avoid that law right now.
There are 2 more questions, and we'll end this with these 2 questions. One question is from Mr. Venkatraman. He is asking, in his address, in his speech at the UN, the Prime Minister of India, Mr. Modi, said India's vaccine production and delivery capacity will be used to help all humanity in fighting this crisis. The question is this even feasible given that the US wants to bring supply chains back to America?
That's a great question. I think that people want a cure or prevention or a vaccine COVID, no matter where it comes from, as long as it's safe and effective. And clearly that runs counter to some of this thinking that everything has to come from the United States. And for example, if the AstraZeneca Oxford vaccine is the first vaccine to be approved and it has high effectiveness rate and it's approved by the FDA, I can't imagine that our government would not procure it, even though it's not made in the United States. Let's say it's made in Europe. You know, that being said, if the first safe and effective vaccine came from India or China or anywhere else, I would assume that either this president or another president would try to procure it. And I think that's a really kind of a good point for us to end on, is that we need medicines that are safe and that work. And that should be the key factor in whether that drug is available to people around the world. And I think as long as we ensure as an industry that our drugs are safe and effective, I think that will defeat some of the nationalistic fervor that we're seeing. In an emergency, if India couldn't make all of the drugs that it needs and it needed help from the United States, I would assume that India would ask for help. Any country would ask for help. So we have to focus on making sure that our drugs work, help people, and are safe. And then I think the nationalistic pressures that we're seeing will eventually fade. But in the meantime, we have to deal with them, and I'm hoping that our allies will deal with it in a rational way, and that we can work on some type of international agreement to make sure that drugs can flow freely among our allies.
The last question now is, do all settlements are subject to land 20 million penalty?
Not all settlements. It's only a settlement where something of value is provided to the generic company. So if the settlement only involves a date in which there can be generic entry, then that would not trigger the statute. The liability occurs when the generic receives something of value, but something of value is extremely broad. So it could include, for example, a contract whereby the brand does part of the manufacturing or distribution, or it could include a most favored nation clause or an accelerator clause. So many of the provisions, many of the types of provisions that are in our settlement agreements now are effectively outlawed under this law, but a simple agreement to end a dispute and find a date of entry, that alone does not trigger the legislation.
Thank you. Thank you, Mr. Francis. Thank you very much. I would now invite Dr. Krishna Ella. Dr. Krishna Ella.
Yes. I'm not sleeping. I'm not sleeping.
Thank you, Dr. Krishna Ella. I'm just making you the panelist. Would you, in case you would like to use any slides?
I don't have any slides, so.
Okay, thank you. You need no introduction, but I just tell only in one line that this is Dr. Krishna Ella. He is the chairman and managing director of Bharat Biotech International Limited. Over to you, Dr. Krishna.
Thank you, Raghupati. I want to thank Srividya. She's the one who sent email to my wife. My wife said, do it. So I don't have a choice. So thanks for Srividya.
Thank you. I appreciate that.
Okay, I think Jeffrey gave a very good presentation, extremely good presentation. I think it's a more specific to small molecule and a little bit of biosimilar. But I'm a vaccine guy. I will talk as an entrepreneur and as a scientist. How do I use the game of intellectual property a little differently? So that will be totally a different off the shelf of the attorneys, what they talk and all that. But how I look at it as intellectual property. I'm a strong believer intellectual property has to be respected by India. When even the political system asked me, do we do compulsory licensing? I said we should not do anymore. We should respect now, and we have mechanism to find a ways to deal with the various companies. There are ways to do it. So I'm a strong believer that once we sign a TRIP agreement, we need to respect 100% the patent issues. There's no choice left for us. And today, I think India, we're respecting that the intellectual property is 100%. So that's a difference. Right now, India is totally different country today. And as Jeff has talked about more small molecule, as you grow the molecular size, as you go into larger molecule, complexity increases. And in terms of the science, also complexity increases. And also the intellectual properties also increases problem. So I'll tell you a very good example. So what happened is in 1985, before 1985 or 86, prior the TRIP agreement, we respected whatever the patent was there before. We will not respect, but after that we respect. That's one of the understanding of TRIP agreement. What happened is in the unfortunate situation in most of the developing world, they missed about the material transfer agreement issues. For example, suppose if I buy one strain, yeast or bacteria, I get it from US, I sign a material transfer agreement. They clearly mention it is for R&D purpose, not for commercial. So even if the patent expired on usage of this biological material, it never expires the ownership of the rights of that property. Whether it's a DNA plasmid or RNA vaccine or even a host or cells, whatever it is, the biological material that we use in a vaccine production or biosimilar production, all covers under that category. So this biological material transfer agreement, ownership remains forever. That is really little put us down in the developing world. And I think, how do we overcome this sort of problems? So that's how I looked at it as a scientist, as an entrepreneur. Okay, let's use the diversity of the viruses, diversity of the bacteria as an again to cover the patent. For example, rotavirus is manufactured by Merck. Rotavirus is also manufactured by GSK. How come if it is the same product, how can the two companies can manufacture? The reason they can manufacture, because the virus strains are different, their morphology is different, their physiology is different, but the end point of diarrhea control is same. I said, okay, let's use the same strategy. So we said we want to use this sort of strategy of diversity of the viruses, diversity of the bacteria, diversity of the vectors, and all that. And that is one approaches Indian government, we took it as a strategy. For example, rotavirus, we looked at Indian strain. It's totally different from the GSK in terms of receptor binding to the newborn babies. The baby, which is a 12 months baby, only can bind to GSK Rotarix. But whereas my Rotaravac will bind to 1 month or 2 months baby, newborn baby. Receptors are different. I said we use this strategy as developing a totally new vaccine. Unfortunately, in India, all vaccines are considered as a new vaccine, Schedule Y. So that's a major differences between a vaccine and a pharma. Pharma is a small molecule, structure is covered, but in vaccine, the strain, the genotypic, clade, whatever it is all covered in a different way. But people are now coming around intelligently that if you take a gene of that and you express as a mRNA vaccine or DNA vaccine or use as a VLP, whatever it is, that can be covered also, sequence data. So that is coming a little complex right now, and people are understanding that game nowadays. I think what is important is the vaccine and biosimilar field. Not only the virus strain or a bacteria, CHO cell line or vector. In addition to the protein modification, protein folding, protein formulation, protein delivery, everything, even concentration of the protein that is used for a indication is also going to be covered in the patent. That gets much more complex. If somebody says X virus, I'm going to use it Y concentration. And if my patent is very strong in data on Y concentration, that somebody wants to come in a Y concentration in that range, it's going to get complicated. And it is going to get now, as we go along, it's going to complicate. Many Indian companies thinking that, oh, if nothing happens, we'll bypass a lot of things. But what will happen is now when I'm exporting to, say, for example, Kenya or Nigeria, and GSK can come to Nigeria and Kenya and block my sales of the product in those countries. So they can even weigh me in India. Okay, why should we fight in India? Let's fight in Nigeria and Kenya. So it can block. So that is a game I think is going to come, and it is already, we are seeing that game coming around. And so we're going to see that issues, but we'll be able to solve. About the COVID vaccine, again, you have so much of diversity of the COVID vaccine and formulation, protein, and how do we come around this one? So we said, let's have a public-private partnership. We took a strategy. Okay, let's we make a inactivated vaccine. So US is more focusing on mRNA vaccine, high end of technology. Suddenly, from low end, they went to the very high end. But now, as Francis was talking about the logistics and distribution chain, and those vaccines are stored at -80, and if you keep it at 4 degrees, only 3 days or 4 days stable. So if you bring that vaccine strategy, put it to India, it is going to be impossible to adapt it to Indian situations. But whereas Indian strategies can be adapted in the US, because we work with different complex situations in a society where the cold chains are very less and we manage a lot of things. And also, very good example, I'll tell you, the rotavirus vaccine, when we did the GSK, when they did, it's a 2 ml diluent, Merck vaccine and GSK vaccine, 2 milliliters. So almost 2000 microliters. So that means a newborn baby has to be poured 2 ml of buffer and vaccine into the mouth to newborn baby. Just imagine a baby cannot understand this when it can spit out and it can lose the vaccine, so much problem. And we asked a question, if 2 ml is a cold chain, logistic is a problem, then how do you expand this? So we make a multi-dose vaccine. We made a 10-dose vaccine in a 10 ml vial, 10 ml dose, and we made them as a drop concept, just 5 drops. You pour 5 drops like a polio drop, 5 drops to the baby. So that gives you 0.5 ml to the mouth. So you vaccinate the people, and it can reach to the entire village, to the rural areas. And that's a game. We do it as a distribution and logistics. We work not only just a thing, we also work on intellectually on the distribution, logistic, and intellectual properties surrounding that logistic issue also. And we filed a patent, a 5-drop concept as a delivery, as a patent, and it has been sanctioned also. And coming to the COVID, that's one of the things we said, we'll line up with public partnership with ICMR. We did the Covaxin, which is now phase 2 completed. And that is getting into phase 3, probably next month or after that. And leave apart, that's just a pure inactivated vaccine. Why we choose inactivated vaccine? Patent issues are less problem, but most important is the oldest gold, the oldest technology, and it will be safest. And also you can even 37 degrees, you keep it for 1 week, nothing will happen for this vaccine. Even 40 degrees, keep it for 1 week, nothing will happen for this vaccine. So we said, okay, this is easier to deliver to the even rural area for us. And we can also deliver multi-dose. I can even 10 dose in a simple vial, which US can deliver only 1 dose in that vial. We can deliver 10 doses in the same vial. So it can reduce the cold space, narrow down. So we put that game into the picture. Second one, we've just, we worked with Thomas Jefferson, another public partnership. They have intellectual properties on rabies platform, when a rabies and a spike protein of COVID join together as a chimeric protein. So when you inject, you are vaccinating both rabies as well as COVID. We said this will fit very well for the developing world, where the rabies is a major problem in the developing world and Africa, particularly Africa and India. One of the major problems is rabies. I said, okay, this will give a good strategy for us. Both COVID and rabies can be vaccinated together. And that gave an intellectual property for us, both MERS, SARS-1 and SARS-2 and Nipah, all these platforms we put in that thing, and we licensed intellectual properties from the Thomas Jefferson. Second one, now third one, we just licensed Washington University. We said, okay, fine, we have 1.3 billion population in India. If 1.3 billion population, 2-dose inactivated vaccine has to be given, whether it is a live attenuated vaccine or the vector-based vaccine like AstraZeneca or any other vaccine, 2-dose vaccine, it has to be given. 2.6 billion syringes and needles are required for India, just for India alone. So your 7 billion population, 2-dose vaccine is going to be 14 billion syringes and needles. I said, just imagine the pollution environment that we are going to create itself, beside the making these syringes and needles. I said, how do we go around this one? We partnered with Washington University, St. Louis. I said, we give just simple one drop on a nostril. And we love this drop concept for us, unfortunately. We like the polio drops. We like the rotavirus. We brought in a success story in a 5-drop concept. I said, can I put one drop to put person, bend them, put one drop there, 0.1 ml, put one more drop on the second nostril, and then vaccinate, and it'll give you protection 100%. Thanks to the Washington University, they published it in Cell and Nature, and that one dose of nasal delivery, giving a sterilizing immunity. Sterilizing immunity means that even virus, vaccinated animals, even the virus doesn't touch even lung cells also. Absolutely clean. The lungs is sterilized, almost like sterile condition, not being infected with the virus at all. That's a sterilizing immunity. It's very rare, usually in a vaccine field. And I think we found this is the first one. And we partnered with the University of Pennsylvania and the University of Washington, because Washington University, the reason is the intellectual property on those adenovirus vector platform, we need to license from them. We said, let's license this entire platform. And we license the platform. So now we have started manufacturing in India. So this is one thing, is a scalable to 1 billion doses. And also I can make a 10-dose, 20-dose vaccine, drops in a vial, small vial, 20 dose. I can distribute even to the villages, to the area where they can put a drop onto the nostril. This is a dream, but we have to see in the clinical how it going to work out. My feeling is if it works in a very high challenging model like monkeys and AS2 mice, it does work in humans also practically. If it work in severe challenging situations like AS2 mice. So we're looking at that angle. How do we have a distribution channel, logistics, reach to the end point in a remotest village where even uneducated person can give this dose nasal drop vaccine to the person so that you don't have to use the syringes and needles. And sometimes what happens in the developing world, when they want to mix a diluent, they even mix some insulin into their diluent. There are some children who died in India also because of mixing insulin into lifelines vials. So I think, they all can avoid this drops concept. So we look at that angle also, how to expand. And we strong believer that intellectual property has to be respected, number one. Number two, intellectual property's public partnership gives great opportunity. Whether the US or India, it doesn't matter for us, but the partnership with the academic and public institutes will help us. And for example, rotavirus vaccine and the Indo-US bilateral program, we work with CDC, Stanford, NIH, everybody, and we have more than 35 patents around that thing, and more than 40 publications around the rotavirus vaccine. So typhoid conjugate, we were the first vaccine company in the world. So again, we have come out as an innovation that more the typhoid problem in the developing world are the newborn babies and 6 months babies who lick the floor, who have unhygienic food in the villages. They get that food and they get typhoid. And the drug, doctors prescribe more, more multiple drugs. And what happened? They're not responding to any antibiotic. Actually, many children are dying in Karachi and Pakistan. And we were the first one in the world to develop a typhoid conjugate vaccine. And we did human challenge studies in in Oxford, Andrew Pollard in Oxford. We did human challenge studies with 120 people who are given vaccinated and placebo, given a live bacteria, infected them. And it covered in one of the major paper in the New York Times, and how that is being created by a small company from Hyderabad. And I think we covered the intellectual property in that angle. Now we are saving a lot of children in Pakistan, Zimbabwe, Malawi, Nepal, and other areas. And we partnered with the University of Maryland on how to do the lot of intellectual property surrounding that area. So I think we have done even some other African problem. We have taken up how to work with Wellcome Trust and University of Maryland to protect intellectual property, at the same time save the children in some of the African new disease. We're working on that. I think I'll leave it there. And so we work not just technology alone, we work on the delivery, cold chain, logistic, the endpoint where this vaccine can reach. And biosimilar is also similar strategies are required. And people has to be concerned about the biological material. Whatever they sign the material transfer agreement, they should be careful about that, what they sign. And that will come one day or other, hit them on that, when the marketplace goes. Thank you very much. Thank you very much, Raghupati.
Thank you, Dr. Ella. There are I think a few questions. Yeah, can you see the Q&A section? Are you able to see this, or I'll read the question to you?
I can. What is that? Some Aradhana Sadasivam?
No, Arvind has asked.
I don't see the question. I don't see the question. Sorry. Oh, sorry.
I'll read it out for you.
Please.
When do you think that Covaxin will come into the market approximately, if everything goes well? Do you closely follow and interact with the vaccine manufacturers such as ZyCoV-D, CHADOX1, and also interact with the team of Sputnik 5?
We interact with everybody. And we know everybody's platform technologies. It's not appropriate to say anything on this sort of webinar, but certainly we interact with them. And second is, when do we come with launching the vaccine? So when we start phase 3 trial, we're going to start 27,000 people in a phase 3 trial in 10 different states. So this is the first time an Indian company is doing 27,000 people efficacy trial in India. Because what our serum is doing is a more of immunogenicity study for AstraZeneca, not the efficacy. We are probably the first company in India to do efficacy trial, but I can't comment anything when it will come, because I know somebody will notice. And but certainly you are going to be sooner, not that late. But the phase 1 and 2 data looks very interesting and very good. Thank you.
Yeah, the floor is open for question and answers. Requesting participants to ask their questions either in the chat box or the Q&A section, or ask the questions directly by raising your hand. Dr. Ella and Jyoti Kumar, we have logged in Mr. Raghupati's name, so his name is visible.
Oh, okay.
Mr. Raghupati has also joined.
Okay.
You can see his name as Raghupati Sundareshan.
Okay. Right. Okay, Sundareshan.
Yeah, the floor is open. Anyone would like to ask questions?
Good.
Nobody is. Then I thought maybe I would like to engage Dr. Ella. Thank you, first of all, for coming. This is Sri Vidya. I'm actually pleased to see how in India, the debate is happening, the innovation versus access debate. A few years back, I was a little more closely involved when our software companies were going through the same debate. And yes, I think India's time has come to look at intellectual property and protecting it strongly, but without compromising access or affordability. I think that's the trick question that developing countries are trying to have to look at. But on the question of biologics, I actually have, there has been a recent congressional initiative to look at the price of Humira in the US, right? It's a BV drug, and there has been a recent congressional question on Humira's price, particularly because in the US, we don't see too many biosimilars, while Europe has taken off much better on the availability of biosimilars, partly because of patent laws and so on. So I was looking at the number of patents, and I thought, this is something that you would like to hear. IMAC had a small note which said that there are 257 patents covering Humira alone. So we went into the database and I was looking at the data, and I'm still, on the early stages. But the last I saw, it looks like there are 461 patents covering Humira alone, and it covers it for more than about 30 plus years. I mean, certainly 38, 36, somewhere around there. Obviously, with biologics, the US has amped up data exclusivity as well. So I think patents is the least of their worries now. Data exclusivity for biologics is 12 years. And of course, there are other paradigms, public funding, public participation of some of these. Public participation, PPAT is another separate thing for the patent office, but certainly public funding of some of these patents. So there are other related questions. So to the extent we talk about India, I think that, we've got to be aware of the balance that has to be struck. And for many of us, that's the issue. The problem is not that we should respect TRIPS. I think the problem is we should do it in a way that actually promotes both innovation and obviously innovation in a way that it's affordable and accessible.
Srividya, I just want to say, typhoid conjugate, we were the first one in the world to develop. We launched it. The WHO said it's a world record-breaking. I mean, sort of a breakthrough innovation for saving the antibiotic resistance problem. But we never charged $10, $20. It's innovation. We have a patent. US also patent sanctioned for us, and Europe also sanctioned. But we never charged $20, $30. We are still selling at $1.50 to UNICEF. So that speaks innovation. We do it, but we see that access is there for everybody. So still $1.50, I consider it is almost like a water bottle cost.
Absolutely, fair enough.
So that's the difference between India and US. US will be expensive, not accessible to the developing world. We are innovative, but accessible to the developing world. So what? If no question?
There is a question from Dr. Aradhana Sadasivam. She's asking, what are the major challenges in commercializing vaccines, especially those coming from academic institutes?
See, I think, you have to remember that 216 candidates of COVID vaccine has been put in. By the time marketplace would take maybe 6 or 7 only going to be the surviving. So many R&D ideas are there, that ideas to make it to reality, to the real situations, to the field. It's very tough. So please keep in mind, the number of vaccine manufacturing companies are very few in the world. For example, in US, only Pfizer and Merck. Come to Europe, again, GSK, Sanofi. You go to Korea, Korean Green Cross, and one more, LG. That's it. So very few vaccine members. It's very tough to survive. Even Novartis was in the vaccine field. Finally, they have to sell it off to GSK. Very tough field. It's not an easy field. You need to sustain, for example, rotavirus vaccine. It took 18 years for us to come to the market. Typhoid conjugate, 12 years to come to the market. And spending, thanks to Gates Foundation, they funded us at least $300 million as a clinical trial program. Otherwise, I would not have made it. By borrowing money, I would not have been successful. It's very tough for an academic institute to make it as a vaccine because R&D is the smallest part in the vaccine field. The major part is the developmental and then manufacturing and then clinical trial. And then reach to the places to UNICEF, to their requirement of their presentation and what they to reach to Africa, to Latin America and all the places is another tough game. So I think it's a toughest field. It's not an easiest field. But the good thing is we save a lot of children. That's what the goodness, happiness of that field. But otherwise, we really don't make much money. I'm telling honestly, compared to the pharma companies. So vaccine companies are social cost companies, corporate social responsibilities more. So I think academic institutes should be careful about anything R&D. It doesn't mean that it turns out to be a product. You have to be cautious about it. I leave it there. Over.
Are there questions? I'm just looking at the chat forum.
Hello.
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 Yes.
Hello, Dr. Ella.
Yes.
Good evening.
Yes.
So the point that you started off with is like respecting the intellectual property right and the compulsory license. I also completely agree with you because there is no point granting somebody a patent and forcing them to give it to somebody. But again, if we see that compulsory license scenario arises only on certain rationales, that when in first place there is somebody who wants to come in, there are certain challenges and all. So don't you think that there can be, or what can be the midway scenarios where, you know, especially in the challenging and testing time, where we can meet the need also as like pandemic or any such things. Like something that comes to my mind is like asking the brand to import into our country, because we have one more condition that you have to manufacture in the, so relaxing on that part and asking the brand company to import it into the country and maybe meet the demand for that time period at an affordable price, or maybe encouraging a midway platform of a tie-up between the Indian manufacturer and the other ones. Don't you think that those options are also viable and open, or can be opened up?
It's a very good question. It's a very good question. I'll tell you one thing. Let's take an example of vaccine. Ask a simple question. Okay, Government of India gives you compulsory licensing. To even if they give a compulsory licensing, to make a product, it needs so many other ancillary things. Whether you need a vector, you need a QC reagent, you need a pseudovirion. There's so many things. Where is these biological materials are going to be available? It's not like a chemical industry where compulsory license is easy to work. Even biosimilar is also very easy to work on. But in a vaccine field, compulsory license is very complicated, not possible to do it. Even if somebody gives a compulsory license to me, okay, make Oxford vaccine, I will not be able to do it. It'll take at least next 2 years for me to develop a lot of things, reagents. Maybe I'm well prepared for the next one, but not this one. So the biological materials availability for QC to developmental and all those things complex. So that's why compulsory license may not work well in the vaccine field. What it works is a partnership. Suppose if the manufacturing process, say for example, I manufacture one process, they can do, I want to transfer to say Sri Lanka. Sri Lanka, they can ask, okay, technology transfer. Let's do it to Sri Lanka. But the professor was telling about the nationalism coming in. So that is getting much more aggressive in the pandemic situation. Chinese wants to have nationalism, Russian wants to have nationalism, Americans wants to have nationalism, European wants to have nationalism. Only India is the only one who doesn't want to nationalism, unfortunately. But what I see is the compulsory license will not work, but partnership will work. Like, for example, if Sri Lanka wants to make it, okay, I'll do the technology transfer, my clinical trial data, animal data, everything I'll transfer. He has to do what they do is they have to manufacture and bridge a small trial and move on to the market quickly. That is possible, but not the starting from the beginning. It's impossible. Am I clear, Rakesh?
Thank you, Dr. Ella. Yeah, thank you, Dr. Ella, for putting your thoughts.
Thank you.
With that, I want to thank Dr. Ella, but I also want to invite Dean Robert Adier to give his concluding remarks and for the panel as well as for the program. Thank you.
Thank you. Thank you.
Can you hear me okay?
Yeah, we can hear you.
Wonderful. Well, let me say I want to thank Dr. Ella for these wonderful remarks this morning, as well as Sean for his remarks earlier. They represent, in some sense, the opportunity for these kinds of gatherings that bring together the academic sector and the industry sector around a particularly topical and important and critical and challenging issue, to make great headway. It's been a wonderful partnership for Texas A&M University School of Law to join together with CII to organize these programs, culminating in today's session. It's the aspiration of the School of Law, given our deep interest in health and intellectual property and access to medicine, and given our similarly great interest in India and global engagement generally, to find ways to build on these kinds of opportunities, to see how can we jointly impact in a positive way, not just the understanding of these issues, not just the economic opportunities available to industry, but really the true health of our population in India, in the United States, and all over the world. This session really has been represented, and in that sense, it sort of only lived out well kind of the hopes and dreams for what we thought of this program at the outset. When Professor Raghavan first came to me and talked about it, I thought it was a good idea. I didn't think fully appreciate how much we would be able to accomplish with it in terms of insight and discussion and impact. And so my thanks to the panelists for today's session. My thanks to all the panelists who have participated in the program over the course of the last couple of weeks. And my thanks to CII for being such wonderful partners in this program. And finally, my thanks to Professor Raghavan for the inspiration of coming up with this idea and for the commitment really to this intersection between intellectual property, health, trade. That is the work that she's been doing as a scholar for many decades now, but is now bringing to bear in terms of having these positive impacts. And so thank you to all for that.
Thank you very much. Thank you very much.
Thank you. I now invite Dr. Ramesh Datla, Chairman, CII National Committee on Intellectual Property Rights and Chairman LACO, to give the concluding remarks. Dr. Datla.
Yeah, good morning and good evening to all of you. Ladies and gentlemen, I, on behalf of CII, I would like to express my gratitude to Dr. Krishna Ella, Chairman and MD, Bharat Biotech, Mr. Sean Brown, Vice President of Government Affairs, Lupin Pharmaceuticals, Mr. Jeff Francis, Senior Vice President and General Counsel, Association of Accessible Medicines, Robert B. Ehday, and Anthony G. Busby, Endowed Dean Chair, Texas A&M University School of Law, for taking time out of their busy schedule to interact with all of us and share their views on healthcare sector, which is playing a key role in saving the life of humans, in addition to creating IP challenges and opportunities for the healthcare sector. On one side, pharmaceutical industries are working on the cutting edge of innovation, be it medical devices, vaccine development, small molecules, or biologicals, to get rid of COVID-19. On the other hand, there is a need of national and global policymakers to work with the pharmaceutical industry to establish appropriate policies for balancing protection of innovation versus access to medicines. It is high time to strengthen the IPR policy regime through legislative, judicial, and executive framework for the betterment of various stakeholders. Therefore, I hope the entire month-long session delivered by various experts on various topics such as issues around patent law and policy, pharmaceutical policy, regulatory issues, IP strategy for healthcare sectors, tech transfers, public-private partnerships, the global trade regime, and other barriers to healthcare and medication gives many takeaways and lessons for everyone. On behalf of CII, I thank all the esteemed panelists for sharing their knowledge with the participants. I would like to convey my special thanks to Robert Hedai, Dean, and Anthony Busby, Endowed Dean's Chair, Texas A&M University School of Law, Professor Srividya Raghavan, Professor of Law, Texas A&M University, and Christine and entire team of Texas A&M University School of Law. Also, very special thanks to Professor Raghavan for her guidance, help, and support. I would also like to thank the participants for their active participation in this month-long weekend executive program on health, pharmaceuticals, and intellectual property rights. I once again thank all of you for making this program very successful. Lastly, I would like to thank the Association of Accessible Medicines, YJ Trivedi and Company, and Lal and Sethi for their support for this initiative. Thank you very much.
Thank you, Chairman. With this, the training program, the executive education program comes to an end. I would request the panelists to kindly stay logged in. The participants can sign off now, please.
Okay, are we on a private session now?
Yeah, I'm trying to set that, but yeah.
Okay.
Yes, okay. Thank you, first of all, to everyone who's joined this session. Again, Bobby, would you like to welcome everyone and kickstart the conversation?
Sure. So let me say again, we thank publicly, but let me thank privately and say how much the law school has appreciated the opportunity to collaborate with so many from CII, from the business community in India, from the academic community in India, and from the pharmaceutical industry. It really, again, I'm not sure it's true of every university and every law school, but for us, this really represents at its best what it is that we are hopeful we can perhaps accomplish. We as a law school. Oh, sir, you're telling me the connection is not good?
Yeah, I don't think we are hearing you, and your frame is moving.
The sound is no good, or the image? Let me stop
Both.
the video. Something else. How is the sound now? Is it any better? Is the sound any better?
Yeah, probably. Just
I could hear most of what he said.
You could hear. Okay. Thanks, Sean.
Let me hold on. Let me try one other thing. Turn this off. Hold on. Close other thing. See if it improves. Any better now?
Yeah, I think it's much better.
Well, I can start again. I think it's again the thinking about this session was to allow us to have a little bit of conversation. I would welcome your insights. School and as a university, Texas A&M is anxious to find ways to continue this collaboration, to find ways that we can identify academic partners, industry partners in India that can enable us to, given our strengths in relevant areas, we are sort of one of the top law schools in the United States around intellectual property and innovation. We are building a new very strong program related to